Over the years, I've gotten a lot of questions about trademarks. How do I use them? What protections do they offer? Do I really need them? And I've seen this done right and wrong. I've seen disasters. I've seen people protecting themselves, but it can be pretty confusing. So I've invited a friend of mine, Tyson Smith, who's a trademark attorney. He's going to come in and help demystify trademarks for us today. You're not going to want to miss this episode. I'm Steve Reed, and this is Brand or Die. All right. Thanks for joining us on this exciting episode of Brand or Die. I've invited a guest, Tyson Smith, on the show, and he's a trademark attorney, and he's got a lot of really valuable insights that I think are going to help a lot of entrepreneurs and business people who have questions about trademarks, when to use them, how to use them, all the little nuances and things. And we're going to hit on some of the big questions that I get asked a lot, to where some of them I kind of know the answer to. And then others, I'm like, you should probably speak to a trademark attorney. So we brought Tyson on. He's going to help us navigate through some of these things at just a very high level so that everyone could come to a better understanding of how to navigate some of these things. So Tyson, thanks for coming on. You want to give us a little bit of background about yourself?
Sure. Yeah. Thanks for having me. This is exciting to be on to talk about trademarks. So, like you said, I'm a trademark attorney. I work at a law firm called Porky Barber, based in Austin, Texas, and focus on trademark, copyright, and what we call unfair competition law, which is just kind of the catch-all term for things related to trademark and copyright. As a trademark attorney, I do everything related to trademarks. So that runs from what we call the prosecution of a trademark, so the clearance searching, to check availability of a trademark, to the filing of an application to register a trademark, working through the registration process, and ultimately getting a trademark registration. And that's kind of what we call the prosecution side of things. And then all the things that go with that, counseling on those type of issues. And then also on what we call the enforcement side of the trademark practice, and that's enforcing trademarks. So dealing with other parties. So if someone is misusing your trademark, we'll send them a demand letter, or helping with online enforcement, things like that, and litigation, trademark oppositions and cancellations at the Trademark Challenge Appeal Board of the Patent and Trademark Office. So just the gamut of trademark law.
Okay, so typically when most people think of trademarks, they think of the little TM symbol or the little R with the circle in it that you typically see. When and how should each of those be used? When do they come into play?
Yeah, it's a good question. So the R in the circle means registered trademark. So once you register a trademark with the Patent and Trademark Office, you can use that by your mark to notify people or the public that you claim trademark rights in it and have a registration for it. The TM just is a designation that means trademark. So it's notifying the public that you claim trademark rights in it, in whatever you're putting it by. So if you put it by a mark, you don't have to have it registered to use the TM, but it's still notifying the public that you claim trademark rights in it.
So a lot of times I'll have people say, I want that little TM to go on every part of my logo. I want it to be on the website. I want it to be in my print material. I want that little TM to appear everywhere across all of my visual assets that I'm getting designed. Is that necessary in every case? What do you recommend?
So I don't know if it's necessary to do it everywhere. It is helpful from a trademark standpoint to put the TM logo or the TM designation or the R in the circle designation, if you have it, have a registration for it by at least the most prominent and public uses of it. Whether you put it everywhere just depends on what you might want. It's not necessary, but it's okay to do from a legal standpoint.
So when you actually have a registered trademark, what does that actually shield you from, and where does it potentially leave you exposed?
Mm-hmm. Yeah, that's a great question, because I think one of the fundamental principles of trademark law that a lot of people don't understand is that trademark rights accrue through use of a mark, not necessarily through registration. Mm-hmm. So just by using a brand or a mark or a name in connection with whatever goods and services you're offering, you accrue trademark rights in And this is an important thing to understand, that it's limited to the geographic area where you're offering those goods and services, or where you're using
Okay.
the trademark. So that's the first thing to realize when you think about, what rights do I have in a trademark. Um, when you register a trademark, it does a few things for you. There are, a lot of benefits to trademark registration, because you get, like I said, you do have rights in a mark. Without registration, you don't have to have a registration. But some of the really big benefits of a registration include nationwide, what we call constructive use. So it's treated as if you use it everywhere. Once you have a registration, you're not limited to the geographic area where you use it. It's treated as if you use it everywhere. So that's one of the first big benefits of a trademark registration. Another one comes from another important aspect of trademark law, and any kind of dispute with the trademark, and that is priority, or what we call priority. So who used it first? If there's a dispute between parties about a particular mark,
Mm.
whoever used it first has the prior rights in it, and has what we call priority. So and you get priority. You can get priority based on your use of a mark in the geographic area you're using it. But as soon as you file to register, or apply to register for a trademark, your filing date is considered your priority date, also nationwide. So that filing date is an important date
Okay.
for trademark registrants. And so the earlier you register a trademark, or apply to register a trademark, the better, because it locks in that filing date as your priority date. So that's another important one. When you think about just having a registration, one of the benefits is just a deterrent. You can use that R in the circle, like we were talking about. And also, when you register a mark, it appears on the Patent and Trademark Office's trademark register. So if anyone is searching, thinking about using a mark or a name, they'll see it on the PTO records, and so it can deter them from trying,
Right.
deciding to choose a mark and use a mark that's similar to yours. And similar to that, and an added benefit of a registration is, if someone applies to register a mark similar to yours, if you have it registered, the trademark office, at least presumably, will refuse that registration of the second comer's application to register a mark that's confusingly similar to yours. So those are kind of two prongs of a deterrent effect for having a trademark registration, when it comes to others that might come up or want to use a mark that's similar to yours. Another important benefit to a trademark registration is it gives you the right to sue in federal court. So if you have to enforce your rights through litigation, there's a possibility, and you may be able to sue in federal court without it, but it just you have the right to sue in federal court, and have standing in court to do that if you have a federal registration. Another really important benefit in our day and age of having a registration is online enforcement. So internet, if someone's misusing your mark online, Amazon, or has products that are rip-offs of your product, or using a domain name that's confusingly similar, or the same, incorporate your mark in the domain name. Any type of online enforcement, it's almost just necessary to have a registration to get the online platforms to respond to your request to have a domain name transferred to you, or have a product taken down. It's just really important to have that registration. So depending on the type of potential infringement that you might see with your mark or your company, if it's online, it becomes extra important to have that registration, or extra beneficial. And then maybe just one other that I'll mention just really quick is counterfeiting. If someone has products that might get ripped off, or have counterfeit products, having a registration is really important and helpful in enforcing trademark rights against counterfeit.
And we see a lot of that on Amazon.
Yeah, Amazon, or lots of the online platforms. And even when it comes to Customs and Border Patrol, if you have a registration, you can have them searching for products coming into the ports. And
Oh, okay.
So with
interesting.
counterfeiting, it makes a big difference.
So you mentioned geography, right? And the geographical area. Are we talking city, state, What do you mean in terms of
So
geography
it's actually the
typically?
actual geography, and so it can depend on what it is. So if you think about a dental practice, for example, the geography is
Yeah.
typically, I don't know what the actual radius is, but 5-10 miles from that dental practice. If you have
Oh wow, so it could be
So it
very
can be
small
very
then.
small,
Yeah.
or if you're online, there's a pretty good argument that you're everywhere, and maybe actually where
Hmm.
your customers are buying or accessing your website. But it is actually the geography. So it's not, there's no you know artificial geographic designation of a city or a state. It's just the actual geography of where you use your mark and offer your services.
Interesting. Interesting. Yeah. Okay. So if you did, let's say you did go ahead and get a trademark registered,
Mhm.
right? But someone, maybe something got missed in the process, and someone has been using either a name or a symbol or something like that, and they've been using it longer, maybe for years and years and years. There's a potential that you wouldn't be able to enforce that trademark on them because of that prior use, whether it's registered or not, whether it's a TM or a registered
Yep.
trademark. Could you speak to that a little bit?
Sure, yeah, and that's exactly right, and that's why that priority that we talked about earlier is so
Hmm.
important. And not only can you, not enforce it against somebody typically, if they have used it prior to your have an earlier priority date, either through user registration,
Mm.
but there's a chance that they could make you stop using your mark too if you're the second or later user. So if you adopt a
Mm.
mark that infringes someone else's mark, they could make stop using your mark, and there's potential monetary damages and monetary risks
Yeah.
as well.
You have a lot of these online trademark services, right?
Mhm.
I've actually used one, and and back in the day, and it seemed like a pretty smooth process, and I got a couple trademarks registered. It seemed to work fine for me, but there's still a lot of lingering doubt in the back of my mind about something. Like I don't know if maybe somebody could come after me in the future, and
Yeah.
so that is something I kind of worry about a little bit. But
Yeah.
what do you say about a lot of these? And I think we already know which way you're going to go with it compared
Yeah,
to
and obviously
using a
I'm a little
trademark
bit of
attorney in these on.
a little bit of a biased, have a little bit of a biased
But
answer to
some of
this,
these
but
trademark services say that you can pay a little extra to get a trademark attorney to help out. Like, what do we make of all that? What's your knowledge of those types of services
yeah,
compared to like your own?
yeah. Well, without commenting on, if someone actually hires a trademark attorney through that process, I can't really comment on that. But as far as, just the
Gotcha.
online services that help you with the filing process, I think it's just important to realize that's what it is. It's not legal advice. It's just a service that
Mm.
helps you through that filing process, and can walk you through that process and help you, get it on file and know, what to fill out and things like that. But it does, it can make it simple and maybe more cost effective up front, to use one of those online services. But I think some of the benefits of a trademark attorney that you touched on already are at least in my opinion, in a lot of cases worth that, at least a little bit of upfront extra cost. So the
Mm.
clearance searching, I think, is something that we typically advise, and is helpful to do, to know if, what else is out there, both from a trademark registration standpoint, to know if the trademark office is likely to refuse your application because it's too similar to another mark that's already registered. And it's also important to just know what's out there, from an infringement standpoint, so you don't, get sued, or have
Mm.
somebody ask you to stop using your mark. There's obviously a cost of having to rebrand, and once you invest
Yeah.
in your brand and get further and further in it and have more invested and more recognition of it, the more painful that becomes. So doing that clearance search up front can be really helpful in helping give you that peace of mind you were talking about, and also just really know and have a better idea of what the registration process is going to be like for you. So that's one benefit, I think, of using a trademark attorney, is they can help you with that clearance process. And you can get on, the trademark office does have a search function that you can get on and search by yourself, the trademark office, and see
Yeah.
what applications.
USPTO.gov.
Yep. And then there's a trademark area you can go and it should be pretty easy to find if someone Googles, the trademark office or USPTO trademark to find that.
Yeah.
And if you're not going to hire a trademark attorney to do that for you, you should at least do some Google searching to see what's out there, and look on that trademark office website to see what you can find and you'd be looking for not just identical marks, but anything that could be confusingly similar when you look at the mark itself and the goods and services it covers. So I think also, when you think about just from a practical standpoint, one of the benefits of an attorney to help you is if there is an issue with your application. So if it sails through, that's great. But I think then I don't know exactly what the statistics are, but something I heard somebody give a number of about 66% of trademark applications are refused by the PTO.
That's pretty
just
high.
Because there's an issue with it, and it could be that they find another mark that they think is too similar, or they might decide it's merely descriptive and doesn't qualify to be a registration or a registered mark. Lots of issues. There could be an issue with your specimen that you submit or the goods and services, and so having that help with trying to respond to those office actions is what they're called. If you receive a response from the trademark office that there's some sort of issue with it, I think that's especially where having a trademark attorney help you with that is particularly beneficial. And then just moving along the process, just with the enforcement and maintenance of a registration after it is registered, I think is another benefit that you don't get with an online filing service.
Yeah. So you could potentially you could have a logo that is a unique name, but let's say your symbol is too close to something else. And let's say you don't have a TM on there or anything. It's just part of your logo. Could you run into problems there if maybe a larger national brand goes, hey, that's a little too close to us? And does it matter if you're in the same category of business or not?
Yeah. So whether it's a word or a design, doesn't matter. You still have a duty, or you could be infringing if your mark is likely to cause confusion. And that's the standard. Is it likely to cause confusion among consumers? And so that's what ultimately the determination is it on whether something is infringing. And so if you come up with a logo and it's too similar to Nike, even if it's not identical, they'll ask you to stop, whether it's the word Nike or something that looks like the swoosh. So that is important to do. And as far as your question about when to start looking at these issues, the earlier the better. The further down the process that you go without doing those clearance searches, the more, the further back you have to go to start over if you run into any issues. So, ideally, and obviously this doesn't happen in businesses all the time, or, sometimes isn't practical, but the sooner the better, and the earlier in the process, the better.
Gotcha. So you would say, like, maybe before you finalize the logo, you come up with a concept and say, okay, this is what we've come up with. We think this should be good. At that point, would it be a good idea to pass it over to the trademark attorney, just have them look into it?
And really the conception stages before you move forward with investing in it at all, I think is the right time to do that.
Yeah. Gotcha. Yeah.
And especially
that seems really smart to do.
Yeah, and especially with designs, because designs, those are more difficult to search also. And I say, especially with not necessarily on the timing aspect, I think, conceptualization, and early is better for designs or words or whatever the type of mark. But having someone search for design for you is particularly helpful, because it's difficult to do that on the trademark office website. You have to have some expertise in that, and sometimes even special software tools that will have that can help with that.
What would be, in your opinion, the types of things you should look for in a trademark attorney? Because you'll probably find a lot of trademark attorneys out there, but what should someone be looking for?
Yeah, so that's a good question. And I think there's probably a lot of different considerations depending on what your needs are and what your budgets are and everything. But I think someone that has expertise in trademarks specifically, and again, this is something that, I probably have a little bit of bias in, but I think it's, if I was looking for a trademark attorney, I'd look for someone that specialized in trademarks. Just like in a lot of things, you don't want to go to a family practice doctor for specific orthopedic issue with your knee, you need to go to the orthopedic
Right.
surgeon, and so that's really, I think, my primary advice would be to just go to somebody that has that specialized knowledge in trademarks.
Cool. And what are typically the costs involved? I know a lot of people would want to use one of those online services
Yeah.
because it's cheap, but on average, what are you looking at in terms of cost? And is there a significant difference between maybe a small business versus a medium-sized business or a large corporation? I'm assuming there's differences in those rates because of the research that has to go into
Yeah,
it,
I mean, I
right?
think
But what would you on average?
yeah, that's a good question. So, the filing fees for an application are 300 and it just changed them. I think it's $375 per class of good or
Yeah.
service. But they also just made some really challenging fee structure changes where you have to, there's an additional fee if the description's over 1,000 characters. If you don't use their stock descriptions, there's an additional $100 fee.
Mm,
So it's a little bit harder to estimate now because of the fee structure for filing. But it starts at $350, and it can go up from there for the USPTO filing fees per class of
okay.
good or service. Typically, we tell clients to just plan on spending, at least $2,500 or so for the registration process, and that could include some of the
Mm,
clearance searching. Um, but it would go up just depending on the issues that are raised. If there's a refusal that the PTO issues and there's an office action that has to be responded to, depending on the issue, that could be something that's really quick and doesn't add a lot of cost, or it could be something that's a lot more substantive and takes a lot of time to write a legal response to it to argue why the trademark office should let it through. So there is a decent amount of variability, but I think in general, if you have in mind that it'll cost $2,500 to $5,000 per application, it'll at least probably be in that ballpark, I would imagine.
the description's an important thing, I think,
Yeah.
because you said they have these kind of cookie cutter default descriptions,
Mhm.
but you may want to include things in your description that specifically pertain to your brand or how you intend on using it. And if you're missing information in that description, there's a potential that you could maybe not be covered for certain usage, right?
Right. Yeah. And that description really is what gives you the scope of your legal protection for your trademark registration. And so that's one of the really important parts of an
Mm,
application is to get that um, the goods and services identification or description right. And so the PTO has some form, they call it the trademark ID of goods and services, the manual of goods and services that you can um, just have some of those, pre-approved
mhm,
descriptions, but you have to make sure that it gives you the right coverage. And if it's not, and a lot of
mhm.
times they don't have one that matches exactly. Sometimes they do, sometimes they don't. But knowing what you're offering and you also need to make sure that what your application covers, that description actually covers what you're using or intending to use, that it doesn't go beyond that as well. And so getting that scope of coverage with the description is important.
So if you need to enforce a trademark, let's say all of a sudden you're going about your day and somebody shares a link with you on social media and says, "Hey, this looks exactly like your logo." And don't you have a registered trademark? And you're like, "Oh my gosh, either they've completely ripped me off or someone came up with the exact same idea." What would you typically do in that situation?
Yeah, that's a great question. And it just depends on, what the actual situation is. There's so many different scenarios that someone, that can come up in
Mm,
an enforcement context. But in the example that you gave with social media, the first thing is to investigate and just understand it and make sure, you actually do have priority, and understanding, what uh, goods and services they're offering and assessing, the strength of your claim against them to see if it really is infringing or how likely, what your chances of success are. And then if it, especially if you have a registration, it's helpful in a social media context then you can go and fill out a form. And this is
Mm.
something that someone could do on their own, especially if you have a registration. Facebook and YouTube and all the different platforms typically have trademark complaint forms where you can submit a complaint, a trademark complaint, where you give them the link to the infringing post, and you put your just describe what your trademark rights are, and then submit that to try and have it taken down.
Yeah, so there could be cases to where, let's say you go through the trademark process, you register your trademark, you're like, okay, I got it. Yes, I'm safe, I'm protected, I have the authority to use this. And let's say this all happened in the course of 2025, right? Let's say I filed January 1, I got it sometime later in the fall, maybe September, and then I go around and I find a company that I think's infringing on my trademark, and I contact them, I do a cease and desist, and it turns out they have actually been using the same logo, the same name, maybe for the past 10 years. That could actually backfire on you, couldn't
Yeah,
it?
absolutely. And that's why the first thing to look at is always, do you really have priority, doing enough
Right.
investigation to give you comfort on that. And because if you do, exactly what you said can happen, and they can turn around and tell you to stop, and it'll backfire.
So, what would happen if you had a trademark issue internationally? Let's say a company in the UK is also selling product in the United States via website, and they've come along, you have priority, but they're using a logo they've maybe clearly ripped you off,
Mhm.
and maybe they have some they're using the same stock photos you're using on your website. They just went and downloaded the same ones. They're just ripping you
Yeah.
off. What what recourse do you have in that
So
situation?
if it's a foreign company using a mark in the United States, the everything is
Mhm.
essentially the same. I mean, there's obviously different dynamics, but as far as legally, it's about use in the United States, and so the approach would be pretty similar. Where it gets different is if you're talking about use or registrations in a different country. So if your company also is doing business in the UK, and you have the same type of issues in the UK with another UK company, and then the hope is that you have a registration in the UK, or trademark rights in the UK. And so then you get into what does it take to have that protection outside of the country, and there's some different mechanisms to
Mm.
do that. You can file trademark applications and register a mark in individual countries, just like you can in the United States, and companies that do a lot of foreign business. Um, it's you know it's a very typical thing for them to do, to register marks in the jurisdictions where they do business. Um, and you can also, there are some international treaties where if you file an application to register a mark in the United States, you can then extend that protection and designate other countries through, the Madrid Protocol is what it's called, or at least one of them. And so those are really when you think about enforcing your mark internationally, it's thinking about, what protection do I have internationally. And you also typically have to work with foreign counsel in a different country, um, and so that that's another element of that as well.
It does sound like there are actions that you can take to protect
Right,
yourself,
right.
right?
And
And that's where you would need to talk to someone who has
yeah, and
expertise.
it is important. It can be important to think about the international elements, especially, if you're a manufacturing business, even if you're importing products from China, for example. There's, even if you're not
Mm.
selling in China, there may be reasons to register your mark in China, to help with, import issues or counterfeit issues, or online enforcement issues. So they can come into play even if you're operating just in the US.
Okay. Now, as far as trademark maintenance and renewal, what does that kind of look
Mhm.
like? I mean, is a trademark indefinite, or does it expire
Mhm.
after a certain amount of time? What
Yeah.
types of things do you need to know about that?
Yeah, so you have to renew your trademark registration after the first 5 years. So you have to, but
Mm.
between the fifth and the sixth year is the timing, and you have to, pay a fee and show that the mark is still in use. Those are the basic requirements to
Mm.
renew your registration, and then every 10 years after that, you have to follow essentially the same process of um, showing to the PTO that you're still using the trademark that you have registered for the goods and services that are covered in your registration.
Cool. What are the renewal fees like for those?
Uh, I knew you were going to ask that.
Just
I
ballpark,
want
is it?
to, yeah, it's a few $100s to do that.
Okay.
So kind of similar to the application filing fees.
Excellent. Hey, awesome, Tyson. I sure appreciate you coming on and sharing some of your wisdom with us. I think that's going to be a huge value to anyone who watches this episode. So appreciate you coming on. I want to give you the last word. Is there anything else maybe that we didn't cover or something else you feel that would be helpful for people to know?
No, I think we covered the bases. I think just realizing the, like we talked about the value of a brand, and doing what you can to protect it. I think, from my perspective, it makes a lot of sense. And, hopefully, people can get something out of this and it can be helpful for them. So thanks for having me on. It's been great.
I'd like to thank Tyson Smith again for coming on and letting us pick his brain a little bit on the subject of trademarks. As you can see, it can kind of be a little bit murky waters if you don't know what you're doing. That's why having someone like Tyson in your back pocket by your side is going to be awesome. So, hey, thanks again. And we'll see you on the next exciting episode of Brand or Die.